This is a video broadcast looking at an overview of some of the issues affecting family law within Europe. My name is David Hodson. I'm a specialist family law solicitor, mediator and arbitrator in central London, working for the International Family Law Group. I want to look at a variety of issues affecting law and practice as far as international families are concerned within the European Union. Where are some of the issues where we come together, and where are some of the issues that are separating us, and where they have an impact on us in law, in practice, before the courts, in the mediation room, and as solicitors. And I want to start with what for the European Union seems to be the biggest problem, certainly across Europe, and that is the matter of applicable law. They are very intent on imposing the concept of applicable law on all European Union countries. And the problem is that there are some countries, of which the United Kingdom and Denmark are two primary countries, which do not operate applicable law. They operate, certainly the United Kingdom, the law of the United Kingdom on all cases, whatever the connection of the parties, wherever there may be their nationality or domicile or residence, they will always apply the local law before the courts, and this has been the position for hundreds of years and applies, apart from a few corporate commercial matters, to all matters going through the courts. This issue is dramatically causing difficulties in new legislation. In June 2011, we had the EU Maintenance Regulation, a significant legislation giving very justifiable automatic recognition and enforcement of maintenance obligations across Europe, a very laudable aim. However, it almost came unstuck simply because of the need for applicable law to be sorted out. In the end, it was through a Hague Protocol mechanism, and congratulations to The Hague for coming to the aid to sort out that particular issue. There is a perception, certainly within the English profession, that applicable law doesn't actually work. There is a very significant body of knowledge now that where, for instance, England is applying English law, and yet a country, perhaps Spain, Portugal, France, Germany, many of the countries of the applicable law regimes are applying English law, there will be quite a significant difference, quite a dramatic difference as far as the outcome is concerned. And therefore, to suggest that an answer to all of the many issues regarding applicable law and other issues of cross-border matters within Europe is simply to say, oh well, let's have applicable law across Europe. It is far from the answer. It certainly doesn't deal with the issue of how actually it is applied in different countries in different ways. There is anecdotal belief that in fact many countries apply basically the law of another country with a very substantial gloss from their own national law. But applicable law is an issue. It's an issue that must be picked up and dealt with. It's an issue that arises in the maintenance regulation I've referred to. It is an issue that arises when deciding which is the best country for parties to commence proceedings, the so-called forum shopping. And the forum shopping is a crucial element, and applicable law doesn't make it any easier. What is a very good development is December 2010, there was an enhanced cooperation regulation entered into whereby the applicable law jurisdictions, the primary ones certainly, have come together and they have agreed when applicable law will be applied, the circumstances, the priorities, the issues. And if there is any country involved in applicable law, that enhanced cooperation regulation must be examined. So the first issue around Europe at the moment is applicable law. How will it actually have any impact? The second issue I would suggest is a crucial one, having an impact in the way in which the proceedings are commenced. And this is Latin lis pendens, basically first to issue. Whoever is the first to issue proceedings secures that jurisdiction, presuming, of course, there is the connectedness with the country. And this is found in Brussels II Revised, sometimes known as the Council Regulation. And this produced two developments, one excellent and one probably the worst element that we have in any family law, I would suggest, as far as I'm aware, anywhere around Europe. The first one was excellent. It simply said that every European Union country has identical jurisdiction for a divorce. and therefore we know what divorce jurisdiction exists. There are about 6 or 7 different grounds, primarily based on an element of habitual residence. That was good, that was commendable. It's the second element which is so destructive of family life and attempts to resolve any difficulties in relationships. It simply said one thing, that if more than one country has jurisdiction, so proceedings could be issued, for instance, in England or in France and in Spain, it only matters who issues first. The consequence has been that lawyers around Europe have put on their training shoes and they run off to court at the first moment they get instructions. They dare not wait. Sometimes it may not be a question of issuing in one's own country. One may receive instructions from a new client and one may say, yes, but you have jurisdiction in another country within the European Union, issue there and issue fast. And cases have been won and lost on matters of minutes. Who issued minutes before the other party? It doesn't have to be closest connection. Many times the court receiving the proceedings first in time actually have the much weaker connection. That is thoroughly irrelevant as far as the Brussels II regulation is concerned. Simply who issues first and fastest. And it's fair to say that there are some jurisdictions, some legal professions around Europe which are faster than others. This is no criticism of those legal professions, it's simply different ways in which professions work. There is a perception that here within England we are a very fast profession. We are geared up to dealing with things very, very quickly. And certainly I and many other practitioners within England receiving instructions from a client where there may be a dramatic difference around Europe would expect to get that client to have instructions fast and issue very, very fast, and so win the so-called forum race to secure the best outcome for the client. What are some of the disadvantages of this first to issue? Well, I would suggest there are 4 of them. First of all, one would never now discuss prospects of reconciliation. This must be thoroughly bad. But for instance, a spouse says, sorry my dear, I've had an affair, it's all over, I'd like a reconciliation. What is that other spouse going to do? Yes, probably they will want a reconciliation. But maybe they say to themselves, well, the outcomes around Europe are so dramatically different, and I shall come on to that later in this video cast. Outcomes are so dramatically different that I really think I ought to issue first, if they're in any doubt about the likelihood of success of the reconciliation. And this is particularly harsh. It means that there are real difficulties in trying to actually have a reconciliation to bring about marriage counselling, and surely saving savable marriages must be the most important task of all. There is no doubt that the European Union, in bringing through Brussels II in this way, has destroyed marriages which were capable of being saved. And sorry, this is a serious charge, but it must be made. Secondly, never should a lawyer discuss prospects of negotiating an outcome. Never write to a party on the other side to say, we've been instructed, we'd like to discuss how to resolve this matter. If there's any risk that they would then go off and issue in another European Union country, issue fast, issue first. Thirdly, don't ever discuss mediation. Don't recommend mediation. I'm a mediator. I support mediation thoroughly and wholeheartedly. It is a very important way forward in many instances, but never in a European Union case in which there is a first to issue under the Brussels regulation. Always issue and then discuss mediation, and simply then what prospect of success of mediation at that particular stage when one party has issued first. And then fourth and last of all, and very regrettably, at the outcome on agreements. The parties say, but we have an agreement, a pre-marriage agreement that says if ever there shall be a divorce, the proceeding shall be in a particular country. That agreement has no bearing, no relevancy whatsoever under the Brussels II first to issue provision. It has no basis, it is given no weight whatsoever, a matter totally at odds with a lot of other European and other national legislation. So for these 4 reasons, issue fast, don't discuss reconciliation if there's any prospect at the other party of issuing first, don't negotiate, don't mediate, and don't rely on any particular agreements. And the consequence is that there have been an increasing number of issues regarding the grounds for jurisdiction, habitual residence, domicile, These concepts are very uncertain and unclear, and we have seen many more litigation and many more cases concerning that. Many of us have been arguing that the first to issue is not particularly constructive, and yet the European Union still believes it's the best way forward. There is a perception they have not been listening to practitioners, but they believe it's the best way forward, and they've recently introduced it into the maintenance regulation in force June 2011 across the European Union to enforce recognised maintenance obligations through orders, agreements, child support arrangements, and again the first to issue a prize. And so again lawyers are having to rush off and issue proceedings fast without trying to negotiate. It is staggering how out of step this is with the whole ethos of family law practice in so many countries in Europe and around the world, which encourages a collaborative, conciliatory approach to trying to find ways to resolve these matters. Third element I'd want to introduce after applicable law and first to issue is the contradiction between maintenance and property sharing. Now, in certain European Union countries, primarily civil law jurisdictions, maintenance and property sharing are totally different concepts. One is dealt with in the concept of the divorce, another is dealt with either outside of the court system altogether or as separate proceedings. Maintenance in this context means needs. Property sharing is the simple division, invariably in many civil law jurisdictions, between what was acquired during the marriage, taking out of account what was acquired before or from inheritances after separation and similar. And in many common law jurisdictions, England and Wales being one primary jurisdiction, maintenance and property sharing are all dealt with together. There are several features in England of a fair outcome. Needs is one of them, maintenance as it's so defined, property sharing is another, and they are all dealt with together. And one of the crucial elements increasingly now across Europe is the separation between countries of maintenance and property sharing. And again, many practitioners, certainly from common law jurisdictions, are very worried about this and are very anxious at how it will have an impact. Surely we need one set of laws, one set of judges, one set of practitioners dealing with all the financial circumstances of a couple on a relationship breakdown. We don't need some parts dealt with in some countries and some parts dealt with in other countries, but that is an increasing trend coming through. Another element that is a feature of family law across Europe is the weight given to agreements. In some jurisdictions, marital agreements are a feature of the culture of the life of the country, entered into at a time of marriage or at a time of commencement of a relationship without any legal advice, without necessarily understanding the implications, in some circumstances evidenced in some documented cases, without even understanding the language which was being used in the agreement. And yet they are a cultural norm. And yet there are other countries, again primarily the common law jurisdictions, where they're certainly not the cultural norm. They are very unusual, they are very rare, and certainly many in the country would never dream of entering into, perceived as unromantic, planning to fail in the relationship, etc. There is a real difference in the cultural expectation, but the fundamental difference for lawyers in many jurisdictions is the impact of separate independent legal advice and disclosure. What weight should be given to an agreement where one party did not fully understand the implications of entering into it, or was so duressed, was put under so much pressure to enter into it, that they really had no choice but to enter into it. The classic scenario, no prenup, no marriage. What does somebody who wants to get married, the marriage is 2 or 3 days away, and we see a number of instances in the courts in England where marital agreements have been entered into the night before, the day before the marriage, where really the opportunity of one of the parties to say, no, it's all off, I'm not signing, is effectively nil. What is the status of these agreements? And again, this is an issue regarding agreements around Europe where there is a massive amount of difference. Some jurisdictions, including other jurisdictions, it's fair to say, around the world, a number of American jurisdictions will simply say, if you've entered into an agreement and you didn't understand what you were signing or the implications, hard luck, contractually you're not going to be held to it. And yet there are a number of other jurisdictions which will say, if you didn't fully understand the implications, or there has been such a dramatic change in the circumstances since many years earlier when you actually signed up to it, we're not going to hold you to it in one way or another. This is a developing area of case law, is a developing area, I'd say, also of jurisprudence and of coming together of various cultures. Certainly many would say there must be support for the more vulnerable spouse, for the more vulnerable financially weaker party, invariably, not always, but invariably the woman who is under pressure to sign this and sign something clearly against, in many instances, her best interest. There is a significant gender element to marital agreements which we cannot ignore, or we ignore at our peril, both in individual cases and looking at the macro aspect of it. Another element is the very different outcomes. What actually happens on divorce? And again, there is a significant difference, I would suggest, between common law and civil law jurisdictions. In civil law jurisdictions, there would invariably be a 50-50 sharing of the assets acquired during the marriage, with some elements of maintenance, and some jurisdictions in continental Europe make very meagre provision for maintenance and needs of one form or another. And yet there are some other jurisdictions, and England is by reputation the most extreme in this, which make most dramatic variations in the financial wealth of the parties, having no difficulty, no anxiety whatsoever into dipping into the premarital wealth, the inherited wealth, the post-separation wealth, if it is needed to provide for the reasonable requirements, the pre-2000 law, now known as needs of one form or another, needs generously interpreted. We are a very needs-based jurisdiction in England, and we would expect to make quite significant provision, particularly for the more vulnerable party, invariably the woman, invariably the mother with care of the children. Dramatically different outcomes. We will very rarely take conduct into account. Many civil law jurisdictions will take the behaviour of the parties significantly into account. Marital agreements will be given different weight. What actually happened about the premarital wealth will be given different weight. What happened during a period of cohabitation treated as if it was marriage will be given different weight. So there is a significant difference in outcomes. And outcomes also depend on finding out about the financial circumstances. Again, there are some differences. Some countries are quite happy to have self-disclosure, self-corroboration. Some countries have very limited investigation powers or duties. Some countries will actually not look at assets held offshore or behind corporate veils or trust entities or similar. Whereas other countries, and again, speaking from experience with England, have the most exhaustive disclosure provisions. Yes, it certainly comes at a significant cost, but it is exhaustive. And we are very used in England to dealing with spouses, particularly in international families, who will try to hide assets, evade their responsibilities, and will make orders, freezing orders, location orders, and similar to find out the particular circumstances. So very dramatic differences, not just in outcome, in finding out what are the financial circumstances and pursuing that particular disclosure. And then I conclude with looking at the different structure of the legal professions. There is a much greater specialisation in some countries than in other countries. There are some countries within Europe which have a very advanced family law profession, with many running into thousands, perhaps even more than 10,000 or more specialist family lawyers. Certainly not all with experience of international work, but it's certainly experience of family law matters. There are some countries, however, where most of the family law practitioners would regard themselves still as generalists, would deal with other areas of family law, where the exposure to international family law cases rarely exceeds beyond the capital city or a few other of the larger cities within the country itself, and certainly not spread right across the country, as in England, as in countries perhaps like Germany and a couple of other continental European Union countries. And the way the professions are organised, again, is very different and leads to a different form of outcome, a different intensity in the way the work is undertaken. And this dramatically affects the outcomes, and it affects the service and the representation. So we are making good progress within Europe, and we must do so. There are many international families, but there are many differences. And so in looking at the overview of these issues, one comes back to the European Union, which has such a crucial role. They have a very fast timescale for introducing legislation. The worry of many of us is that actually they're introducing the legislation without having an infrastructure of legal professions, family law specialists around Europe that are actually able to cope, understand, grasp and work with the legislation that's being brought in. A plea therefore for the European Union: yes, the work you're doing is important, it's valuable, it's crucial, but make sure please that there is the family law structure within the professions, within the courts services, within each country that is able to actually deliver the service that you expect from your legislation. And at the moment, that is severely lacking in places. Thank you very much indeed.